That's true. Listen up. I know firsthand how limited a vessel's medical insurance can be. This is why you need reliable medical coverage. Moore Dixon offers comprehensive global insurance tailored for yachties, covering everything from emergencies to routine checkups with flexible options and a single point of contact. Moore Dixon has been voted best health and medical insurance by captains and crew, including myself. Don't wait until the unexpected happens. Get covered today. Visit mdbl.im or email them at inquiries@mdbl.im for a free quote. Welcome to part 3 of our 3-part legal series, Death and Accidents at Sea. If you haven't listened to part 1 and 2, I really encourage you to go back. Each episode builds on the next and gives important context for this final part. I'm joined again by Adria Notari, maritime lawyer who focuses her practice on accidents at sea. She's here to help us better understand how to protect ourselves legally in this industry. In this final part, we're focusing on legal support and protection, when to contact a lawyer, how to choose the right one, and what crew and families can do better to protect themselves before something goes wrong. Let's get into it. In this final part, I want to focus on protection and how and when to bring legal support. When should a crew member or a family member start thinking about speaking to a lawyer after a death, suicide, or even a serious accident at sea?
Right away, as soon as possible. As soon as the family is notified, they should consult an attorney, and they should consult their own attorney, because as we mentioned before, the investigation by the yacht's insurance company, that's going to be slanted to protect their side of the story. It's not going to be slanted to protect the crew member's side of the story. The same thing with law enforcement investigations. So it doesn't hurt. And in most situations in the United States, it doesn't cost the crew member anything to get an initial consultation and see, like, what are my options? What are my remedies? What are next steps? What can be done? You know, in cases of an injury or incident, the company should be providing medical care and treatment right away. No questions asked. Even if it was the crew member's fault or not the crew member's fault, or there was no negligence, none of that matters. If the crew member is injured during the employment contract period, they're entitled to prompt medical care and treatment at the employer's expense, not that the crew member should be paying for his or her own medical care. And the injured crew member should be consulting an attorney right away and saying, like, this is what's happening, what should be done. Sometimes there's nothing that can be done because, hey, the employer is doing everything that they're supposed to be doing. They're doing it just right. Okay, that's great. That's the ideal situation. And then the crew member can be cured. They reach that level of maximum medical improvement. Then they can be fit for duty, and then they can go back out to sea again. That's the ideal scenario. But life isn't always the ideal scenario. So isn't it nice to consult an attorney first and see what are the options? What are the available remedies? What can be done? Are there some benefits that I should be getting that I'm not getting? And an attorney can look into all of that for you and advise the crew member properly, because the employer is never going to advise you on what your rights are as a crew member. Never.
A lot of the questions that I get asked is like, okay, I had an injury. I'm an American. My boat is a Cayman Island flag vessel, and I'm in France. What attorney do I get? Do I go to an American attorney because I'm American? Do I go to a French attorney because I'm in France and the injury, even though it happened on board or maybe even happened on shore leave, happened in French jurisdiction? Or do I go to Cayman Island and reach out a lawyer there because I'm under that flag state? How does it all work? Or do I get various lawyers involved?
You can get various lawyers involved, but I would say that the most important factors to look at are the citizenship of the crew member and not the flag of the vessel, but the owner's allegiance. So we see so many situations where the actual owner of a company has a flag of convenience on the boat. So the flag on the boat doesn't mean anything. It's a flag of convenience. The actual allegiance of the owner is, where is the owner located, operating their business? What is the owner's national allegiance? Is it a U.S. company based in Fort Lauderdale that just has a flag of convenience on the stern of the boat? Then the flag of convenience can be disregarded, and we look at what are the real ties of the owner. So that's what I mean when I say the allegiance of the owner.
The owner, mean the employer.
The owner or the employer, exactly.
Yeah,
exactly.
Because I see where you look at the boat registration, and yes, it's a Cayman Island registration, but then who owns the vessel is actually in America, right?
Yeah.
Like the address is like New York, and you're like, oh, okay, so then that would be that I would more than likely need a attorney in the U.S.
Correct. So exactly. So that's what in this age of flags of convenience, they're prevalent. They're so prevalent. So it's not a surprise anymore. That's usually the norm, that the vessels, the owner's interests are in one country different from the flag on the boat. That's true. That's what we see more often than not. In legal actions, the courts don't pay too much attention to the flag state if it's a flag of convenience. You know, I have so many situations where the vessel is flagged in St. Vincent or the Marshall Islands, even though they have absolutely no link whatsoever to St. Vincent or Marshall Islands. They don't have an address there. They don't have employees there. They have no presence in those countries. So that flag of convenience, it's just for convenience. So we disregard that. And for the real legal analysis, as far as the lawyers are concerned, they're going to look at those two things: the citizenship of the seafarer and the real citizenship of the owner employer, not the flag of convenience nonsense, but the real base of operations of the owner or the employer. So the law bypasses all those formalities, and we really look at the nitty gritty, like behind all of those shell corporations and flags of convenience, who is the real owner? Who is the real employer? And where is that base of operations located? So I would say for a crew member, those are the two most important factors. If you're a U.S. citizen, contact a U.S. lawyer. And if you're not a U.S. citizen, look beyond the formalities of the flag of convenience and look at who is the real owner or employer. Are they based in Canada? Are they based in the United States, even though they have a Marshall Islands flag on the stern? You're not contacting a lawyer in the Marshall Islands is going to be useless. So consider your own citizenship and the base of operations of the employer or owner.
Are we looking at our C agreement and who is employing me, right? And like maybe looking at where they're based? Or am I also looking at, for example, on the boat registration, you can see maybe it's a Cayman Island registered vessel, but then under who owns that vessel, then you'll see that they're based in New York. Like, I don't know, formality.com is the company, and then like the address is New York. So who is responsible? The one under the registration of the vessel or the employer on my agreement? Because I have seen sometimes that in the C agreement, it's the management company who's actually almost like the employer because they're giving you the secret.
The legal obligations are to both. There are some legal obligations that the owner is responsible for, and there are some legal obligations that the employer is responsible for. The owner and the employer is not always the same person or entity. So it's both. It's both. It could be both. So the best bet as a crew member is to find out those things. Who are the people that are listed on your SEA? It should list the employer, it should list the owner. And then once you're on board, is there a certificate of insurance or a certificate of financial responsibility in case of crew member incidents, in case of crew member repatriation? Those are very helpful things to identify the owner, the employer, and the insurance company. Those are going to be the responsible parties for your case.
Okay. And I heard on another podcast, somebody talking about flags, states, and they said, and correct me if I'm wrong, they said that your employment laws are determined by the flag state country. Is that correct?
Generally, yes, but not always. Not always. First of all, sometimes there are situations where the actual SEA agreement will state that this employment is governed by the laws of, I don't know, let's say Malta, just as an example. Even though the ship is not Maltese flag, the crew members are not from Malta, nobody is based in Malta, but if the contract could say that. So in that situation, no, I don't think it's automatically the flag state. Nothing is automatic. It's not automatically the flag state. Another situation is when, as I've mentioned, these flags of convenience issues. If we forget about the flags of convenience and really look at who's the identity of the real owner, the real employer, and even though they have these flags of convenience, their base of operations is in Fort Lauderdale in Florida, then we're going to be able to bring a case in the United States and have U.S. law apply. We've done it before. So it's not automatic. And the reason why it's not automatic is because, first of all, it's because boats move all over the world. So because of that transient nature, you don't know where the incident is going to occur. You don't know where the boat is going to be docked at any particular time. The boats are mobile. The boats are moving all the time. Mm-hmm. And you're also going to have so many different nationalities on board. That's often the case too. It could happen that you have everyone on board is from the same nationality, but it's not the norm. It's not mandatory. And I would say it's not even like usual. It's kind of an exception. So because of all these multinational factors, you're not always going to have an automatic answer like that, oh, the flag state is going to determine what employment law applies to you. Maybe not. If the vessel comes to the United States and there are ties to the United States with the employer or the owner of the vessel, regardless of the flag and regardless of what the contract says, then you can file a claim under U.S. law, especially if the crew member is a U.S. citizen. So it's not an automatic answer that, oh, it's automatically going to be the flag state law that applies. Not always.
Exactly. And then when it does apply, does that mean that whatever laws are implemented in that country on the shore side, does that transfer to the vessel, or they have completely different set of rules for, a Malta vessel versus a citizen of Malta working?
Right. Exactly. These are all questions that arise because of the multinational nature of seafaring. These are questions that arise. So I'll give you a situation, a scenario. Under U.S. workers' compensation law, the rules and the remedies and the rights are different than under U.S. maritime law for seafarers. They just are. So in the United States, that's not the correct answer. If you say like, oh, well, if I was injured on a U.S. flag vessel, then U.S. workers' compensation employment law applies to U.S. seafarers? No, that's wrong. U.S. seafarers have their own body of maritime law that protects U.S. seafarers. It's not that U.S. employment law is going to apply. It's that U.S. maritime law is going to apply.
Yeah. And that's very important to understand because, the way they portray it in that episode that I watched, it was like, oh, well, you're covered by the country of the flags. And I'm like, highly unlikely. But I just wanted to, he's not a lawyer. Of course, he's just somebody with a lot of knowledge in the maritime industry. But I think it's misleading to say that you have employment rights through your flag state. You know what I mean? You might have some, but it will depend on who's behind it, how it's set up. There's a lot to unpack.
I don't know. I don't want to argue with another podcast's like opinion without having heard the whole podcast myself. So it maybe what they're trying to say is there are flag state protections for seafarers working on boats that are registered under that flag state. Yes, there are. That is typically, in general, that's true. If you're on a Panama flag vessel, then that the flag state, Panama, has maritime laws in place that govern Panamanian seafarers or seafarers working aboard Panama vessels. Yeah, that's generally, as a real blanket, broad generalization. Yes, that is true. But there's always, because of the fact that vessels move and people are from different nationalities, and that not only is the crew from different nationalities, but the interests, the boat owner and the boat management company and who your actual employer is might be based in a different country than the flag state. The flag state isn't the be all end all. That's what I'm trying to say. So I don't necessarily want to attack that other podcaster's opinion, but it might not be the only remedy. There might be things, sometimes we have to look beyond the flag state because of the realities of yachting with the flags of convenience. Like that's not a new concept. Flags of convenience have been on the rise for, over 50 years. So it's not a new concept, and it's wrong to limit ourselves to just what the flag state governs or what the flag state stipulates are the crew members' rights. Sometimes we have to look beyond the flag of convenience, very often.
Absolutely. When crew members or families are trying to get advice from a lawyer, what are the questions or what are the things that they have to think about when choosing potential correct lawyer? Do they have to be a maritime lawyer? Or can they be a lawyer that just focuses on injuries? What are the specifics that you suggest people to look after when choosing a lawyer?
Well, I think that a crew member should consult a maritime attorney for crew member cases, for crew member claims. Even if it's an injury that occurred while you were a crew member, the maritime law is so complicated and it has so many differences and nuances from land-based injury law that it's in your best interest as a crew member to get the advice of a maritime lawyer. Because, there are some excellent personal injury lawyers or workers' compensation lawyers that handle land-based cases for people that are injured at the workplace on land. And I wouldn't be able to handle those cases because I don't know the nuances of that particular area of the law. But they might not know the intricacies of like this flag of convenience and the SEA and the Maritime Labor Convention versus the Jones Act. And it's dangerous if you're handling a case that's not like your specialized focus because you don't know what you don't know. So then a surprise might come at you like, oh, the statute of limitations is different, or we only had a certain amount of time to make a claim and now the time has passed and we forfeit our claim because we weren't aware of that difference in the time limitation. So my advice would be for a crew member to consult a maritime attorney. And then what questions should you have for this maritime attorney? Well, have you handled these types of cases before? What about if, have you dealt with cases like this where there are different nationalities. In other words, that the seafarer is a citizen of a different country than the boat owner or the employer, because those are all factors as well. Those are the questions that an injured crew member or a crew member's family should be asking to a maritime attorney, in my opinion.
And are there any specific things across the board that will potentially block the opportunity to have a case that we should be aware of?
I would never say never. I would never say never. That's every case is different, but there are some general, like one that comes to mind is the general statute of limitations under US law. Remember, under Panama law, it might be different, or whatever law governs. But the question about what law governs, that's something that a lawyer has to help you with anyway. So the number one thing is consult a lawyer, right? So having said that, I would say like the statute of limitations, that's the period of time that the crew member has during which he or she can make a claim. So under US maritime law, a crew member has 3 years to make a claim, and we call that the statute of limitations. If the statute of limitations has passed, if it's 3 years and 1 day after the incident, then you are forfeited. You are past the statute of limitations. You cannot make a claim. But there are always exceptions. Let's say it's a repetitive injury that started here and then you resolved, but then it manifested again. Maybe the statute of limitations lapsed for the first injury, but not for the second one. So that's why I never say never. But in general, that is one of the limitations. Under maritime law, you have 3 years to make a claim against your employer as a seafarer under the Jones Act. Another challenge or hurdle that comes to mind is something that under US law, the defendants, so the vessel owners, the employers, the insurance companies, they'll use this as a defense. If a crew member was injured in the past, and let's say the crew member had a prior wrist injury with surgery and physical therapy and rehabilitation, and then the crew member went back to work and didn't disclose that prior injury. They hid it. They didn't disclose it on the medical questionnaire. They didn't disclose it during the pre-employment examination, and they just kept quiet about it. Then in the future, they're working on board and they injure that wrist again. Then guess what? The employer is going to say, no, we're not responsible for your medical care and treatment because you had a prior injury and you didn't tell us about it. You didn't disclose it. Whereas when I explained to you before, if you're injured on a vessel, it's almost automatic that you're entitled to medical care and treatment. This would be one exception. If they said, you had a prior injury and you didn't tell us about it. You didn't disclose that. You hid that from us. And that was, shame on you, that was malicious. You should have disclosed that during your medical exam. Instead, you weren't open and honest with us. So the law is going to punish you, crew member, and you're not going to get that medical care because you had a prior injury that you didn't tell us about. Mm-hmm. So if something, those are just some very broad, generalized concepts that come to mind as those would be limitations to a claim.
But if you disclose that you had a previous injuries or a previous illness, does that automatically puts you in a position where the vessel is not entitled to give you medical care?
No, on the contrary. If you disclose it, that's the right thing to do. So if you say, I'm a crew member, I'm working on this boat, I am delighted to be on board, I'm so enthusiastic, but let me just, in the sake of disclosure, I need to tell you, I had a prior wrist injury. I fractured my wrist. I have, plates and screws. I had surgery. I had physical therapy. Now I'm fit for duty again. I'm good as new, but I need to tell you about this. And then if you're fit for duty and you're capable of doing your job, the company should still employ you in theory. But Then if you get injured again, then the company can't say, oh, but that's a prior injury. And you can say, no, I'm still entitled to medical care because I told you about it. You know, so the right thing to do is to disclose it. The crew member can jeopardize their medical treatment if they don't disclose it, if they're not honest about it, if they don't reveal that. And the company is going to find out once they do an x-ray and they see that you have hardware in your hand, in your wrist. That's, but that is a defense that the yacht companies, owners, insurance companies, they're going to use that as a defense to say, oh, we don't have any responsibility to provide the medical care and treatment for this crew member because they were hiding a situation from us. They were hiding their real medical condition from us. So we're not responsible for their medical care and treatment. They're not responsible for that. So all of those things, the maintenance and the MMI, all of that goes away. That's a bad thing because that can ruin your maintenance and cure claim. It can ruin your entitlement to the medical care and treatment. And just like if you wait too long and you don't file a claim within 3 years under US law, you'll be forfeited from making a claim as well.
And even if you're no longer working for that vessel or employer, you still are able to make a claim?
Yes. If the injury or illness happened on that vessel and you're not working on the vessel anymore, that's, of course, yeah, they're still responsible if you bring the claim within the statute of limitations. Correct. So you have to look at when did it happen? Did it happen while you were employed for that particular vessel? Then you're not working for that vessel anymore. It doesn't matter. You can still bring a claim against that vessel because the injury or the incident manifested while you were under their employment.
And what are the legal myths around death, accidents, and crew rights that you see causing the most harm?
I would say the first myth that comes to mind most often is when a crew member thinks like, oh, we can't do anything about it. Nothing can be done. That is a huge myth because there doesn't even have to be a specific incident for a crew member to have a legal remedy. There are types of work that involve strenuous labor, repetitive lifting, working in enclosed spaces that over time, it's been documented that over time, you develop cumulative trauma. So even though you didn't have a discrete incident, you didn't have a slip and fall incident on a specific day, or a piece of machinery caused a bruise or a laceration in a specific incident. It could be something that's just because of that repetitive work over time. I see it most in my practice for housekeeping department jobs, welders, that repetitive motion or repetitive lifting or working in enclosed spaces in awkward positions over time, it causes injury to your bones, your spine, what have you. And crew members don't always think, oh, this is there's something that can be done. So that's a myth. That's a myth that, well, if it's something that's just accumulated over time, then you don't have a case. Oh, that's wrong. There are cumulative trauma cases, repetitive lifting injuries that you do have a case.
What needs to happen in order for you to say, you know what, I need legal advice?
Okay, great question. Absolutely. How do I know when it's time to speak up and hire a lawyer? So if you have one of those cumulative trauma cases, if it reaches the point where now you have a herniated disc on your lumbar spine and you need surgery, then that's like, okay, my employer is responsible for my medical care and treatment. Why? Because this is something that happened while I was employed by that owner or that company or that employer. This is something that happened while I was contributing to their job, to their mission, to their productivity, and now I'm injured. So I see that housekeeping. People suffer like repetitive lifting trauma to their joints, their knees, their elbows, their wrists, and they might not know it right away, but just one day they say like, oh, I've got this uncomfortable pain. And so they report pain. And maybe they get a lighter schedule or light duty, and they do that for a couple of days. And maybe that resolves the symptoms. But then when they try to resume their full scale job again, the pain is unbearable. So it reaches a point where this repetitive trauma injury is affecting your ability to work. Or the more serious scenario is that now you need medical intervention, you need surgery, you need lumbar disc fusion on your back, or you need joint replacement, or you've got, cartilage on your knees, which is, worn out, and that's making it impossible for you to bend and squat and do the kind of activities that your job requires. So it has reached a level where you need surgery, or it affects your ability to work, or both. Then yeah, you do have a claim for the repetitive trauma, even though there wasn't one specific incident. It wasn't an isolated incident. It was just something like develops and accumulates over time because of excessive hours, excessive lifting, awkward positions, not just one isolated day, but over time. And there are certain jobs where specialists have done studies about human ergonomics and how these different positions, or how these different jobs over time cause this debilitating trauma to the body, where you need medical care and you won't be able to resume that job again. Well, if employers know that, or they should have known that, then when something does happen to you while you were working for that vessel, they have to provide your medical care and treatment. And if you're not able to return to a seagoing position again, then you're also entitled to compensation for your lost wages, because, hey, guess what? I can't work as a crew member anymore because now my back is injured, or my knees are bad, or whatever the case may be.
What is your last piece of advice for all the listeners here today?
There's so many pieces of advice that it's very hard to identify one, but I would say like the most important thing is to not be afraid to speak out. If you don't report something on a vessel, and when I say report, we have to be very careful how we use that word. It doesn't have to be a formal report to the flag state authority. It can be as simple as just reporting something to your supervisor. That is considered reporting a situation. So crew members cannot be afraid to report incidents, report unsafe working conditions, report sexual assault or sexual harassment, report that they are feeling like depression or anxiety or some kind of like mental illness. My overarching advice would be that to not be afraid to report things. There are realities of life about working on boats, but if we crew members and the seafarer community and people like me who support the seafarer community, if we don't speak up about it, it's like it never happened. It's like it doesn't exist. So it's up to us to report these things and speak up. If there's a situation at work where they're asking you to do something unsafe, don't just do it and say, oh, I'll push through and just suck it up and do it. That's wrong. The right thing to do is to speak up about it, report it, say something. Oh, this is unsafe. The way this is set up, it's unsafe. This is what we need to do to make it safe. And then I'll do the job. So I'm not opposed to working, but I want to work in a safe environment. But the very basic reporting is what we need to raise awareness, and then raising awareness leads to change, and then making change prevents these incidents from happening again. But if people are afraid to report it, which is so often the case, unfortunately, then there won't be any change in the industry. It's just going to keep happening because, oh, we didn't know about it, or it was underreported. How many times do we hear that things are underreported? So that would be my number one. If I had to choose one, that would be my number one overarching advice for crew members is we need to report. We need to report when there are incidents or or unsafe conditions, we need to report that.
Absolutely. I agree with you. I think that for so long we have normalized keeping quiet, not reporting, that now we really have to shift the narrative. And even not just you who might be suffering or something's happening to you, if you're a bystander, you can also report. You know, you don't have to be personally suffering to report what you see happening. So I think everybody has the capacity and the responsibility in truth to, you know, make these reports and speak up about what's not okay and what's safe and what's unsafe. So yeah, I love that advice, because I think that's really the foundation of changing the narrative that has been going on for so long, that is obviously not supporting the industry as a whole. Adria, thank you so much for joining us again, for continuing to support the community with such clear and grounded legal education. These are difficult topics, but they're important for anyone listening who may need legal advice or wants to reach out directly to you. You can contact Adria Notari through her maritime law practice. Her website is down below. All the contact details are in the show notes. Reach out to her. And if you're unsure whether your situation warrants legal advice, is always better to ask early than wait, like Adria mentioned multiple times. And yeah, thank you for listening. And I'll see you on the next episode. Thank you, Adria.
Thank you, Marién.
That brings us to the end of this series. If you haven't listened to part 1 and 2, I really encourage you to go back. This is a full conversation, and each part builds on the last. And if you haven't watched our previous Seafarer Rides series with Adria, I highly recommend starting there as well. The links are below. This series is about understanding preparation and knowing your rights before you even need them. If this conversation resonates with you, feel free to share with a friend, a family member, or someone working at sea. The more informed we are, the safer we become as a community. See you in the next episode.
If your brand belongs in the heart of the yachting world, this is where it happens. Yachting International Radio reaches over 1 million yachting professionals and enthusiasts every month, with 77 million impressions, 220,000 social followers, and 74,000 podcast subscribers. Our hosts are insiders, crew, captains, CEOs, trusted voices shaping the industry. This is targeted, high-impact advertising in a luxury niche. Visit yachtinginternationalradio.com/advertise. Your audience is already listening.